Andre Pizzuto, President of the Chamber of Architects. There's also discussion going on at the moment about these two planning bills, Bills 143 and Bills 144. In your opinion, and now speaking as a professional, are you concerned that these bills prove that the government is completely controlled by big developers, or is this just, usual rhetoric by activists who just oppose any sort of progress whatsoever?
I would rather focus on the text of the bills themselves and their consequences. The bills come with some changes which are positive and others which we think are incorrect and they shouldn't go through. So the source of this reform, the origin of this reform, was the need to suspend permits while appeals are ongoing. And as we said in our press release, it was preposterous that we had a situation where I have appeals ongoing and meanwhile the developer is just going ahead with the works regardless. And even worse was that properties were being sold while appeals were going on. People were moving in, and then suddenly they end up with no property because their permit's gone.
So to clarify, this is such a development which is happening. Someone has an issue, a planning issue with that development. They appeal, and while that appeal is being heard, and that appeal can obviously stop the development technically, the development is completed.
This is what was going on. Yeah. And what worse than that, it was going on. Sometimes appeals took so long that in the meantime the property is built, it is sold, people move in, and we end up having potentially permits being revoked while people bought after people buying
and they're not even in the house.
Okay, so how does this happen exactly? So if somebody buys a property, I assume they wouldn't know that this appeal is going on, right? Because I don't imagine you're going to buy a property. Or would it be sold at a discount? Or will the banks actually give you a loan for that? Will the notary get involved?
Well, the banks, if you're going to buy a property through a bank loan, the likelihood of them giving you a loan or a sanction letter if there's an ongoing appeal is negligible. I think the banks don't do that anymore. But there are obviously people who buy in cash and they also potentially just buy it without bringing in a professional to look into the property before, checking for these things. I've had cases where I discourage my clients from going ahead with an acquisition because there's an ongoing appeal, and they decided to go anyway with the acquisition, and then obviously later on the permit was revoked. So I don't know what happened to that client, but these are real issues, and something needs to happen. And basically what our position was, because we understand both sides of this debate, was to try to find a balanced outcome which envisages the suspension of the permits, but concurrently a shortened time frame for the appeals to happen, to kind of keep it fair on both sides, because obviously an appeal, having a permit suspended during an appeal means that there are significant costs to keep a project on hold, but at the same time the rights of those who feel aggrieved should be respected and should be protected, and so the ideal is, in our view, is to keep a shortened appeal process, an efficient appeal process that ensures that the permit is suspended while it's being deliberated upon.
So let me just to close this off, I'm very curious. What happens in these real cases when somebody buys a property and it then turns out, and then the permit gets revoked after it has been purchased? Is the responsibility on the property owner to regularize? Is it on the developer? Is there anything they can do, or they just wait in limbo for the planning authority to come with the bulldozer any fine day?
Well,
what happens exactly?
So what happens? What happens legally is in every contract, the vendor, the one who's selling, the developer in most cases, guarantees that the property is built according to permits, according to the regulations, etc. So once that guarantee is not fulfilled, falls short of the promise that is entered into in the contract, there is the possibility for the buyer to kind of try to quash the contract and get his or her money back. Now, what has been happening was, in some cases, some of them notorious, where they apply again with the planning authority to get a permit, to try to get a permit a second time. And then, obviously, if the planning authority grants it the second time, then the issue, unless there are further appeals, then obviously the matter is resolved at that moment.
It's obviously a very long way of going around it, I guess. If you could, so we have two bills. I was wondering whether you could kind of walk us through what each of them seeks to achieve, and then maybe we can kind of look at the positive and the negative, because my impression is that there's both. Okay,
so just at the onset, we were consulted on one of them, but the one on the appeal process.
And you were consulted so specifically because you were told it was going to be published now, or were you consulted as part of a broader process?
We had no idea when exactly it was going to be published. I mean, there were rumors, but we didn't, and obviously there was also kind of a lot of time passing from when the Prime Minister promised that reform was going to happen till when it actually eventually got published. So, I mean, there was clamour for this reform.
So this is the reform, this is not just a stopgap bill. Is this being viewed as a kind of as a reform of the...
Well,
do you think?
I mean, it wasn't... So, as I said, the original intent was to fix the problem of the appeals process. Now, on top of that, they've added other things.
I see, okay.
Okay, so the bill we've seen is the one related to the functions of the EPRT, the Environment and Planning Review Tribunal, and the Court of Appeal in instances of planning appeals. And then there was another bill related to changes within the Planning Act, the one regulating the planning authority. Now, on the first one, we were consulted. We consulted for a number of months, for over a year, I would say, on the concepts, the principles that should be in this bill. And again, we reiterated every time our position, which was to have 3 months before the APRT and 3 months before the Court of Appeal, and then obviously the statutory timeframes for filing and responses, etc. So that was our position. It was public, and we kept pushing for that. Now, eventually, what came out was, rather than 3 and 3, it was 5 and 4. But I mean, it's pretty close to what we wanted anyway, and the spirit of keeping a short time frame was there, so we had no problem with that. So that was fine. But they also added some other stuff which we had not seen, particularly in relation to the ability of the tribunal to modify the permit, and also the part related to the Court of Appeal sending so revoking a permit but not making it definitive, sending it back to the tribunal to decide again. Okay. That was not in the discussions that we had. And then on the other bill, there were other reforms that are not related really to the appeal process, but introduce mechanisms for the Executive Council of the Planning Authority to make modifications to the development plans and to the mainly that was the main issue that we found with the bill that was the second bill that was presented in Parliament.
Can I override the local plans, existing policies?
Yes.
Is that a good thing though? I mean, if the policies are full of loopholes anyway.
No, the policy, look, all the plans need to be revised. They need to be, frankly, scrapped and we do them from scratch, because they were, in my opinion, they were poor when they were published. So it's not just not just they're old, but they were bad, in my opinion, at the time. I don't want to get too technical. I mean, I've studied planning, so I can get as technical as you wish, but they have fundamental flaws, conceptual flaws, and they have planning paradigms, planning concepts behind them that are very old. They're from the 1960s, and sustainable planning and comprehensive planning and spatial planning were concepts that did not exist in the 1960s. And we are burdened still with these local plans that, I mean, we can see the outcome of the local plans all around us. So
why don't they just update them?
Because there is a fear of doing it, in my opinion. I mean, there seems to be a reticence to do it because they're afraid they'll open up Pandora's box and everybody will want to change things and in their favor and this and perhaps kind of keep the lid on and just leave it there and maybe do a bit of tweaking is an easier way of doing things. But I think we need to face the reality that these development plans have caused serious problems. I mean, the most obvious one to me, but perhaps people don't make the association that frequently is the issue with transport, with traffic, and to me, it's very clear that the cause of all this is the local plans. So they cause this problem. That the local plans and another thing which is barely mentioned, the temporary provision schemes of 1988. Those were another disaster, in my opinion, where basically they extended development zones all over Malta around the villages, and that was the beginning. And then the local plans just made.
How
it.
do the local plans cause traffic?
Because basically what you have is what the local plans and the temporary provision schemes did was, rather than concentrate development in a certain area, like here, for instance, and have people within walking distance of their needs, we have a situation where all the villages were expanded, and they have to travel to get around. And I can give you an example of how the local plans and how, in general, planning policy is making the situation worse in retail, for instance. We have in the local plans envisaged a lot of town centers, okay? And these town centers are meant to be the kind of the center for shopping and retail, etc. And they were fine. So you've got the town center in Valletta, so you have Republic Street and Merchant Street, and you have Bizazza Street and all this, and in Slema. And over time, we started getting these shopping centers, which were not planned for, but they were added on through development briefs,
the shopping malls,
modifications through local plans, etc., etc. And we ended up with, I'm not going to mention names, but notorious shopping centers spread around, which are out of town centers. They're not in the village, and they're not in the center of the towns and villages, so you need to get there by car. That obviously introduced new traffic patterns, new movements, which were not there in 2006. We didn't need to travel to Mosta or to Shaira to do shopping or to, so these are new commutes that didn't exist before. Now, on top of that, we have schools being built in ODZ, which weren't there before. So we have new trips going to the areas which were not planned for all this traffic, and this incremental and piecemeal changes in the local plans caused this chaos and the streets is part of the problem.
So,
besides other policies which, for example, force us to dig holes between party walls, to build car parks under the ground, with the presumption that nobody is going to use public transport. So we're digging holes in the ground, putting neighbors in danger because their buildings may or may not be stable, creating a problem of landfilling. All the noise, all the inconvenience, all the dust that's generated, and this is a result of the planning policies.
And it feels like would I be correct in saying that kind of the proposals are a bit an acknowledgement of that the planning process has failed, because you're saying basically that the PA will get to step in when the policies or the plan or doesn't align with kind of what we want to accomplish at this stage.
I mean, I think the planning authority knows that some things need to be tweaked and fixed in general, but the council of the Kamra, tal-Periti, believes that this is not the right way to do it.
So the bills have been controversial. If you could kind of point to maybe a few proposals which do make sense, and maybe the ones which you feel are the most egregious, the most problematic.
from on the one on the related to the tribunal to the planning appeal, I would say the part where the tribunal, the Court of Appeal is no longer allowed to revoke permits.
It's positive,
Yeah.
or
No, positive, no. So let's go through the positives first, because there are a few, and it's important they haven't been highlighted. Firstly, the shorter time frames, but also the complete digitization of the process. So the process is completely digital all the way through the Court of Appeal, which means that for the first time in Malta's history, a court process is going to be done digitally, electronically, no paperwork, and this is intended to make the process quicker. Now, if this works, potentially it could bring about reforms in the wider justice system to speed up the civil courts, for example.
Yeah.
So there are possible benefits that might come out of this. There are other interesting provisions, such as the ability for the tribunal to appoint experts, which they didn't have before. So the tribunal could appoint experts to give it expert opinions on whether something is going to have an impact or not.
And when we say tribunal, we mean like you just essentially have one adjudicator deciding. Like, how does it work? Kind of?
So the appeal has two stages. There's the first part, which is before the EPRT, the tribunal, and that is the tribunal is made of 3 people
Appointed by government.
appointed by the now is going to be the president. Before it was the prime minister.
Okay.
But, I mean, and it's they decide, and obviously there's the parties would be the planning authority defending the decision, and the permit holder, and if there's a third party objected, the third party as part of the process. And then once a decision is taken by the tribunal, if there is an aggrieved party, that goes to the Court of Appeal. So it's a 2-stage appeal process.
What about this issue that people who object to a development, and then the courts or the tribunal rule that it's vexatious, then that person will risk getting fined for €5,000?
So the issue of frivolous and vexatious appeals is a real problem. It's not something that is
Made up.
It's made up. It's a real problem. We have cases. We've seen cases. I think you've probably heard of them, where you have neighbors fighting with each other and they end up trying to get in their way of getting their permits, and then it keeps going on with the BCA after that, with contesting meta statements frivolously sometimes as well. So this is a pattern that we do. It's not thankfully that common, but it exists. Now there was not. What they've done here is introduce a kind of a deterrent for people to stay filing appeals and wasting everybody's time over issues that are not planning issues, and the fine. They introduce a fine. Now we said, listen, the fine might have, while we understand the reason for it, might have a chilling effect. It might kind of scare people from filing an appeal, even if they have the right to do one, because you never know what the tribunal is going to think about your appeal. So we said, listen, we are proposing that fine should be commensurate to the size of the project, because the size of the project kind of has a kind of gives you an indication of the impact of an appeal and the
It will
the
scare
damage.
people off, though, for sure.
Yes.
But
But
then
like if you don't know who these people on the tribunal are. If they deem your appeal frivolous, who's going to risk taking this plunge if they risk getting slapped with a €5,000 fine?
Yeah.
I mean, not everyone's super rich, right?
Precisely why we asked it to be changed. So, I mean, if it's a proportion of the planning fee, of the appeal fee, then a fine could be even €100. It doesn't have to be 5,000. It depends on what it is that you're appealing.
Then I guess it's not so much of a deterrent.
More concerning, yes, but I mean, then the calibration of the fee, I mean, I wouldn't get into that. I mean,
Yes.
but what's more concerning is that they did not give a right of appeal on the fine itself, which we think is a bit excessive and draconian as a measure.
Yeah, and in fact, I think that would, in a sense, solve it, because at the end of the
Yes.
day, you can kind of make your case before
Exactly.
a court and say, listen, this is the reasons I kind of. There was also an issue with the appeals. There are concerns that only people who have objected to a development within the initial representation window would be allowed to appeal. Now, you've said this is incorrect. Could you explain that?
So let's talk about how you can become an objector. I use the term objector even though it's not in the law because it's what people commonly use as a phrase. The correct term is representee, although in the new law they're calling it interested third party. So they're changing the nomenclature again. But let's use objector because that's what everybody normally says. So what happens is this. A Periti files a planning application for a client, and when we do so, there is a phase called vetting. So the vetting process is one where a vetting officer, an employee of the planning authority, goes through the submission that is made, checks that all the submission requirements have been met, and calculates the bill, the planning fee. Okay, so the vetting officer sends a letter to the architect and to the applicant saying, listen, you need to give me these other documents, and you need to also pay this fee, the development planning fee. Once everything is set, and you also need to upload the planning application form with the signatures. That's normally the standard letter that we get at the beginning. Once all of this all the requirements are satisfied and the payments are made and the forms are uploaded, the application is validated. And that's when the process starts. And then you get the site notice affixed on the building, you get the PA number, that's when the PA number is also created, and that phase, the validation, triggers a number of processes. One of them is the opening of the window for third parties to appeal. So the appeals can be filed by anybody, anybody who has planning grounds to file an objection. It could be a neighbor, but it could be someone from the other side of the island. This is why also NGOs are allowed to get in, because they're not necessarily neighbors, but they have an interest because they are within their statutes. Their role is to protect the environment.
Development, the thousands of objections. I mean, this is you can object.
So in that 30-day window or 20-day window, they insert their objection and they register themselves as interested parties. One important thing to understand is that before 2016, that appeal, that representation used to come with an explanation of what you're objecting about. In 2016, it wasn't as explicit. The law said that you need to register your interest without necessarily explaining why. That measure was intended for people to kind of be able to follow the application even though they don't have a problem with it at that stage, because at the time when the site notice was fixed, they don't really have any objection at that stage, but
you want updates.
You want to keep yourself abreast of what's going on so that if something happens down the line and the drawings change, the plans change, maybe later on you will have an objection to file and then you kind of insert it at that stage. What they've done here is they said, listen, together with your objection, you need to also explain what your grounds are. What the bill also says, though, is that you can change your grounds later on. And you can change them all the way till the very end when you have to file a response to the case officer's report. So at the end of a planning application process, before it goes to the board, the case officer who's processing your application does a summary report of the policies that are applicable, the communication that is done with the Periti of the application, and the representations. And then at the end gives a recommendation. That's the format of a case officer report. After that report is published, you are given a number of days to respond and the date of the hearing. And that date applies both to the applicant and to any representees, any objectors that there may be in that case. So all of them, we all have a deadline to file our objection, to file our responses, and those responses go to the planning commission or to the board. So the board sees the case officer's report, the response of the applicant's Periti, and the response of the objectors or their consultants to that response, to that report. Now, when the hearings happen, these parties are also, well, except the planning authority, so the applicant and the third parties, if there are any, are present for the hearing. And they, besides putting things in writing, they also say orally their position and express their opinion to the commission or the board. And then the board decides. So what's happened basically is that the 30-day period for the appeal, from the 30-day period from when the site notice is affixed till when you appear before the committee, you are allowed to make submissions. And according to the provisions in the Development Planning Act, not the tribunal, not the Bill 143, not Bill 144. All the stuff that you put in between when the site notice is fixed till when you respond to the case officer's report can be included within the scope of your appeal before the tribunal.
Okay.
So there's nothing being excluded from this. What the objection seems to be is that, listen, first of all, there was a thing of the 30 days, which at the beginning was not being. There seems to have been misunderstanding about what came out, but in actual fact, it is not just within the 30 days, but even after. But my reading of the bill, and this is perhaps something that needs to be also clarified by the minister who put this forward in Parliament, because it's important also to know that the parliamentary debate, the interpretation of the law comes also from the parliamentary debates. So when a minister says, this is what I meant, that becomes part of the interpretation of the law. One of the clarifications that I think would be good to have from the minister is if I file a very vague objection at the beginning and then I change it later on completely, is that allowed? Can I do that within this? Can I appeal then on the second grounds rather than on the first? Because if that is allowed, then this objection is no longer necessary, because I mean it's clear that nothing has really changed effectively.
Andre, if you were a big developer, would you be pleased at what the government is proposing for this reform?
Well, obviously, the developers are.
And not just the objection phase on the whole reform.
I think with respect to the issue of the more controversial stuff that is in the other bill, Bill 143, related to the Planning Act, I think they would be happy to some degree, because the ability to change the plans much more expeditiously without needing to go to Parliament can work in their favour if that's what's going to happen. But again, as we also said in our press statement, the law is only as good as those people who are appointed to work to implement it and to kind of make its provisions work. So I mean, if there is a suspicion about everything, then I mean,
do you trust these people who have been appointed in the planning authority?
Look, I think the planning system itself needs a complete overhaul. So I think it's more about the inability of the planning authority so far to actually do planning. I mean, that is, I think, the fulcrum of the whole debate, and why I think we're in a situation today where we have all these protests and this anger towards the industry. I think the anger is justified. I think most of members of my organization are unhappy with the situation that we are in, and the reputation that our industry is in. And keep in mind, besides all of this planning protests, there are also the situation with buildings collapsing and all of this. So, I mean, there's very little to be proud of in the way things are being run at the moment. So the anger is justified, and I think the response through these bills is insufficient. And I don't blame the NGOs for being suspicious
Yeah.
about the intents behind some of the provisions.
So just this issue in terms of planning, right? So, I mean, the way I see it is, and correct me if I'm wrong, but it seems that everyone seems to be working in silos, right? So, for example, person A wants to build an apartment of up to 6 floors, and he'll do so. Right next to him, then is a townhouse. Then is an empty plot. And then is a smaller apartment of up to 4. Up to 4 stories. Everything is completely legal,
Yes.
but the fact that they're all next to each other makes the landscape look quite
Yes.
ugly. Whereas, for example, you have other islands like Santorini, like Hydra, where you see all the houses and they all look similar. The planning looks proper. Who's actually taking care of the general landscape?
Nobody.
Nobody is.
It doesn't exist. This is the problem of the local plans. The local plans created a system of speculation. And this situation, this system is visible. This is what we're looking at. I'd like to compare, I like to kind of counter sustainable development and speculative development in this way. Sustainable development is development which gives value to everybody around it. While speculative development sucks out the value out of everybody else around it. So there is no community benefit in speculative development, while sustainable development should, and it does, because it doesn't look only at the interests of the person in development, but looks at the wider well-being. Now, the role of planning authority is to encourage and to ensure the sustainable type, not the speculative type. But unfortunately, the local plans created the latter. So when you have a planning document which says, in an area which is currently 2 floors, you can build 4. What you're saying is pull the buildings down. That's what you're saying.
Yeah.
And you're not doing it in a coordinated manner. You are telling them to do it on an individual level. You're telling each landowner at his own time, with his own design and with his own.
If you want to, yeah.
Do it. Pull your building down and build flats. Now, if I've done it in a time when I could build 4 floors, then I've got 4 floors. If I've waited a bit longer and I now can do 7, I'll do 7. You know? So this is speculation. This is a speculation.
But then would you have it, for example, let's say you have a house that is, every house is 2 stories, and you make a decision that, okay, this area can rise to 3 or 4 because the population has grown. Do you say everyone has to wait until the same point to do it? Like, how would you kind of go about it?
This is why we asked the government to kind of entrust us with coming up with a comprehensive proposal, a proper proposal. But we need to start looking at broadening the scope of the way we do things. I mean, if we are going to, if there is a real need to make the density of our urban areas larger because of our population pressures, then it makes more sense to try to develop entire areas at a go, or and have so the ideal system is this: you have a master plan for a particular area, redesign it, design the roads, design the transport system, design everything, including the benches, if possible, the letter boxes, everything, the waste collection system. The whole thing needs to be studied and analyzed. The need for energy supply, the stormwater systems. These are not things that are being planned by the planning authority. So, and this is why we have the situation that we do, because we are only looking at giving out permits. As the planning authority only looks at giving out permits.
Yeah.
And we always look at planning in terms of rights, in terms of development right. I have the right to build 4 floors, and the planning authority's kind of intended, implicit role is, does he have a right or not? Then if he does a right, I'll give him the permit, but without regard to the impacts of that decision. So this is why we need to have a much deeper conversation about a planning system.
And how has your offer to kind of lead the process been received?
Well, we haven't met the people.
No, but you're saying this for a long time. You've kind of been volunteering to kind of take. Are you kind of? Is there interest? Is there genuine kind of?
Well, on the planning reform, I mean, we have been, especially in the recent months, bouncing off ideas both with MDA and with the NGOs, and so we have ideas of what needs to happen. But to do something like this with the is before we get into doing it, we need to be sure that people are receptive to this change. Otherwise, we'll end up wasting our time.
You
And
say
we
receptive
also,
to this change, you mean receptive to the possibility of, for example, certain villages being that you can't go up a certain height, and
but also, because I think it's something we need to also start discussing, is fixing some of the mistakes that we've done over the past 40, 50 years. So undoing some of the stuff that's happening.
so like demolishing buildings.
Demolishing buildings.
Yeah.
In the context also of what also we've seen in Parcheville, for example, okay, and other areas where we've seen
Chaos.
we are seeing a situation of existing buildings built over the years, some of them in layers with decades in between, which are unstable. So if you see all the buildings that collapsed in the past 4 years, excluding the one in Cordine, where Jean-Paul Sophia died, they were all buildings next to construction sites, and most of them, it seems like the pattern is that they collapsed because they were badly built, or something was done to them over time that rendered them unstable. So the minute you put out the other building, that it kind of destabilized the whole situation. These issues, together with other issues that I like, seismic design or design for earthquakes and all this, kind of indicates that we should start considering clearing up certain urban areas which are of poor quality and rebuilding them properly. This is something that is not, I'm not inventing the wheel here. This is not something, maybe it's new for Malta, but this is something normal. This is called urban renewal. So there are things that at least happen, for example, in port areas, for example, or, so we have Genoa, Valencia, these are all towns that went through this. Obviously, maybe not on the scale that we need to do, because I think we've made such big mistakes.
and we're densely populated, I guess. So
that we need to find solutions that are particular to us, perhaps, but yeah.
So
Do you
this
think
will involve like moving people out and saying this area?
Well, it might do. I mean, we'll see. I mean, people are moving out anyway, but on a plot by plot basis.
Yeah.
But the big question though is that does anyone have the guts to do this? At the end of the day, there's no way on earth that any of this that you're saying can be done without annoying some people. You
For
can't.
sure.
And making some people either lose money or lose the possibility of making money. Does any politician or political party with a chance, with a snowball chance of getting elected to parliament, have the guts to do this?
I'm not sure people will lose money with what I'm saying. Well,
Not have the
or
potential
not-
to make as much money, maybe.
maybe, but then it's a trade-off between public good and private interests, and I think the government's role is to protect public good first of all.
Yeah.
Final question about the bills. So going forward, do you think they're good enough basis to kind of, let's say, if there's a parliamentary process where some amendments can be made that they can kind of stay as they are, or do you think it's more a matter of go back to the drawing board and start afresh?
I mean, the one of the bills is the 143 is proposing amendments to the current law. So some of the things that are being proposed, I think, are good, but there are some which are a bit very questionable because of the way they are envisaging, as I said, changing the development plans. I'm hoping that the government will consider the amendments, because in our press release we published 2 reports proposing amendments, and I'm hoping that we will have meetings in the next weeks to kind of go through them and hopefully have them adopted. So far, the feedback, the formal feedback I received was positive to our proposals. Now, obviously, we'll have to see what actually comes out of it.
Andre Pizzuto, thank you very much. Thank you for joining us.